Let me put this gas.
It's being live stream.
Mr. Johnson, we're in a hearing, please.
The meeting is being recorded, but yeah. I ain't hear what you said.
Ms. Simmons, would you raise your right hand and tell me that your hand is in the air?
My hand is in the air.
Ms. Nicole Simmons, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Mr. Johnson, can you unmute? Mr. Johnson, would you raise your right hand and tell me that your hand is in the air?
It's up.
Mr. Johnson, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, Mr. Johnson. You put your hand down. Ms. Alexander, the state of Texas has informed me that they have an agreement with the parties in regards to this motion.
Yes, Your Honor, they have.
Your case has been called. Your witnesses have been sworn.
The state would call Miss Simmons. Okay, and as it relates to Wiltavian, there was actually an order that was done back in 2017 where it found that dad was the father. Is that correct?
Yes.
Okay. And for Mayana, we did some recent DNA testing. Is that correct?
Yes.
Okay. And I did let you know that the results came back that it was 99.999% that Mr. Johnson cannot be excluded, that he is the biological father. Is that correct?
Yes.
Your Honor, the state would enter the DNA testing results as it relates to Mayana.
Ms. Simmons, I just placed on the screen a copy of the DNA test results for the child Mayana. Is it okay if I look at this?
Yes, sir.
Same question, Mr. Johnson. Is it okay if I look at these DNA test results?
Yeah.
State's Exhibit A is admitted into evidence. Based on the admission into evidence, the State's Exhibit A. The court's going to find the DNA testing was completed in this case with the child Mayan based on those admission into evidence that Mr. Wiltavian Johnson is the biological father of that child.
Okay, so Ms. Simmons, you have both agreed to joint managing conservatorship, and you will be the person designated to designate the residence of Mayana in Jefferson County and contiguous county, and that's the same as the prior order. Is that correct?
Yes.
And it's going to be the standard possession order as it relates to Mayana. Again, that's the same as what was in the previous order. Is that your agreement?
Yes.
How is Mayana covered with health insurance?
She has Medicaid.
Okay. And we did come to an agreement. Mr. Johnson is not currently working right now, but he's going to go into choices, and we based his child support on minimum wage. Is that correct?
Yes.
And that he has 2 other children. And when I calculated the child support, it's going to be $235, and the cash medical support will be $25. And both of those will begin May 1st, 2023. And he gave dad credit for 2 other children. Is that your agreement?
Yes.
Okay. Now you did both live together, and you separated in December of 2021, and you're asking for retro child support for Mayana from January 2022 to the present. And I calculated that to be $884. Is that your agreement?
Yes.
Okay. So Mr. Johnson does owe some arrears, and we calculated what those arrears would be and then added on the $884 for the retro child support. Is that your agreement?
Yeah.
I'm going to ask you some questions in a second, Mr. Johnson. Hang tight. And the arrears that dad owes as of April 26th, 2023 is $16,459.89. And then when we add that retro child support of $884, his total arrears that he will owe is $17,343.89. And dad is going to pay that out at $100 a month, and that will begin May 1st, 2023. Is that your agreement? Ms. Simmons, is that your agreement?
Oh, yes, ma'am. I thought you was talking to Watay.
No. And Mr. Johnson owes some medical support arrears, and that was $530. Oh, hold on. I think that's an 8.
$533.28.
Yeah, thank you, Judge. I couldn't read my own handwriting. And as of April 26th, 2023, he owed $533.28. And we're going to order him to pay that out at $15 a month, and that'll begin May 1st, 2023. Is that your agreement?
Yes.
Do you feel that this order is in the best interest of Maya and for both the children?
Yes.
Are you asking the judge to grant these terms?
Yes.
No further questions, Your Honor. Mr. Johnson, as I just asked Mom, you guys do have an agreement that Mom is going to be the joint managing conservator and she will designate where Mayana lives within Jefferson County and contiguous counties. And that is the same as the previous order. Is that your agreement?
Yes, ma'am.
I'm sorry, what was that?
Say yes, ma'am.
Okay. And it's going to be the standard possession order. And again, that's the same as what was previously ordered. Is that your agreement?
Yeah.
Okay. And you have agreed to go into the Choices program to help you find employment. Is that your agreement to?
Yes, ma'am.
Okay. And you have two other children, biological children, other than Waltavian and Mayana. Is that correct?
Yes, ma'am.
So when I calculated the child support, I gave you credit for that. Your child support is going to be $235 and the cash medical support will be $25. And both of those will begin May 1st, 2023. Is that your agreement?
Yes, ma'am.
And the arrears amount and the retro child support amount that I discussed with Mom, do you agree with that?
Yeah.
And then you're going to pay that out at $100 towards those arrears beginning May 1st, 2023. Is that your agreement?
Yeah.
And on the medical support arrears that you owe, you're going to pay $15 a month towards that, and that will begin May 1st, 2023. That's your agreement?
Yeah.
Do you feel that these orders are in the best interest of Mayana and for both the children?
Yeah, sure.
And are you asking the court to grant these terms?
For Mayana, yeah.
No further questions, Your Honor.
I got a question.
Yes.
So the controlling order at this time is the case that shows that he's supposed to be paying $255 a month for one child.
Yes, and I gave him credit for one other child.
Okay.
But
With
this
the child support that you've set in this order is actually $20 lower than that child support that's in that case. Correct?
Yes, and
So how do
again,
you get $884 in retroactive child support if the child support's lower?
I calculated what it would be for one child, Your Honor, with two other children, and that was $180. And then I did the difference between those two and calculated that by, I think it was 17.
That's not how you do it. Well, did you say the parties were living together for a period of time, Miss
We
Alexander?
separated in December of 2021.
Okay, how long were they living together?
Oh, I didn't ask them that, Judge. I apologize. I
You
just
don't
did
think
the
he should be
retro.
entitled to any type of possession credit if they were living together?
Yeah, we can.
Yes.
Hold on,
I
Mr.
did-
Johnson. I'm asking the state the question.
Judge, I did the retro from January 2022. They'd already separated at that point. Possession credit for the Waltavian.
For the time period they were living together.
My apologies, Judge. I didn't even think about that.
So explain to me again, though, how you got retroactive child support on a case where you lowered the child support by $20 a month. Retroactive child support, Ms. Alexander, on a child that you're adding to an already existing SAPSR is based on the difference between the new child support figure and the old child support figure. So you'll have to explain to me how you got $884 in child support when you actually lowered the child support by $20 a month.
I get what you're saying now, Judge. Well, because how I did it was I looked at the time in 2022 from the retro, and I may have done it wrong. My apologies on that. I calculated it what it would be at that time with him unemployed with two other children, because he would have had two children at that point, and then it would have been it was 232.
Yeah.
And then for one child with two other children, I calculated it was 180, and I did the difference of those two. Did I? I'm way offline.
Yep. It's just the difference between the child support figures. Unless you've got accurate wage information for every single month that you're calculating retroactive child support. But if you just did a raw figure of the child support was $255 and now we're lowering it to $235, I mean, technically speaking, you can't have negative retroactive child support.
So you're saying there wouldn't be?
No, he's ordered to pay less child support now than he was ordered to pay before.
Okay. I'm going to defer to the court on that one, Judge. I will be honestly tell you, I'm a little confused right now.
Mr. Johnson, how long did you and Miss Simmons live together?
Really, it was off and on since I got out of TDC.
Okay.
Like in 2015 or something like that. 16.
Okay. All right. But there was no set period of time. Sometimes y'all were together, sometimes you weren't.
Yeah, something like that.
Okay, and that's okay, Mr. Johnson. I mean, this is real life now. This is what we're dealing with. Ms. Simmons, in our state, if you guys were living together for a substantial amount of time, I should really be looking at the arrears finding in this case and see if Mr. Johnson should be given some credit for the time that y'all were living together. But if y'all were kind of living together on and off, a week here, 2 weeks there, no weeks for several months, I mean, is that how you would describe it, Ms. Simmons?
No, it was like months, years, but just on and off, like breakups. We'll separate for a couple and we'll come back together.
So according to the pay record, according to the agreement that y'all reached today, you said that right now, according to the pay record, Mr. Johnson owes you $16,459.89, right? That's what the pay record
Yes.
is. All right. Do you think, Ms. Simmons, that Mr. Johnson should receive any credit against that for the time that y'all were living together? And if you say no, that's fine. You don't have to say yes, he should get credit for that.
I can't say yes and I can't say no because we have our own personal issues when we
There
separate.
you go.
And I do feel entitled to money, but at the same time, it's not about the money. It's about him and his kids.
Okay. And that's all I needed to know. Okay, Ms. Simmons?
Okay.
That's fine. Ms. Alexander, anything further?
Nothing further from the state, Your Honor.
Mr. Johnson, do you have anything else you think I need to know about this case before I approve the agreement? You're muted, Mr. Johnson. It's okay. It happens sometimes. There you go.
Yeah, nah, I'm saying I'm all right.
Okay. The court's going to find that the court does have jurisdiction. I'm going to approve the agreement that y'all reach, except for the retroactive child support.
Okay.
There's no retroactive child support to be granted in this case. I just don't see the calculation coming out the way it is. And I may be wrong, but that's the way I've always calculated retroactive child support when you're adding children to an already existing order. But the rest of the agreement will be approved. Mr. Johnson and Ms. Simmons, what's going to happen now is Ms. Alexander's office is going to send me a proposed order. If it matches what I said here today, I'm going to sign it, get it back to them. Then they're going to make a copy of it and send it to each of you. Okay.
In the mail or through
All
email?
right.
However they send it to you before email or mail, however. Ms. Laredo, do you
All right.
solemnly swear the testimony you're about to give is the truth? The whole truth and nothing but the truth. Here today.
Yes, sir.
Thank you, ma'am. You can put your hand down. You have any other witnesses, Ms. Alexander, besides Ms. Laredo?
No, Your Honor.
All right. In case, let's see if we got some service on this case. Going to find that Mr. Lopez was personally served with citation in this case on December the 22nd, 2022. He has not filed an answer.
Thank you, Your Honor. The state will call Ms. Laredo. Ms. Did we recently do some DNA testing on both the children with, as it regards to Mr. Lopez?
Yes.
Okay. And the DNA testing for both the children came back that he was the father. Is that correct?
Yes, ma'am.
All right, Your Honor, the state would enter the state's exhibit, the DNA testing for both children.
Ms. Laredo, I've just placed on the screen a copy of the DNA test results for the children. Is it okay if I look at them?
Yes, yes, sir. Yes, Your Honor.
State's Exhibit A is admitted into evidence. Based on the admission into evidence of State's Exhibit A, the court's going to find that DNA testing was completed for both children with Mr. Lopez, and I'm going to find that he is the biological and now the legal father of those two children.
Ms. Laredo, who do the children primarily live with?
With me.
Okay. And who makes the major decisions for the children?
I do.
And who makes the day-to-day decisions for the children?
I do.
What decisions, if any, does Mr. Lopez help you with?
None. He has not visited or seen the baby since he left.
Okay. And when did you both separate?
That's like the second week of January 22.
2022?
21. I'm sorry, 21. Is it 21? Last year, the second week of January.
Okay, so that would be
Sorry.
January of 2022. 'cause we're
22, yes.
2023, correct?
Yes, ma'am.
Okay. Do you have any concerns as to any family violence issues between you and Mr. Lopez?
No, ma'am.
Okay. Do you have any concerns if your address is put into the court record?
No, ma'am.
Okay. Does Mr. Lopez know where you live?
Yes, ma'am.
Okay. What kind of visits does Mr. Lopez have with the children?
He has none.
He's not seen them at all since you
No.
separated?
Yes, ma'am. That's correct.
Okay. Would you have any concerns if he was to maybe have some visits to start with a phased-in visit, maybe start with some supervised visits?
Yes, I would prefer supervised visits first.
Okay. How are the children covered with health insurance?
I have them on Medicaid.
Okay. And do you know if Mr. Lopez is currently working?
I haven't spoken to him, but I know I passed through where he works at and I see his truck still there. The same place he used to work at.
Okay, when you lived together, did you know where he worked?
Yes, ma'am.
What kind of work did he do when you lived together?
He does kitchen cabinets.
Okay, and how much did he make?
Minimum $750 a week to $900 a week.
Okay, and when's the last time you spoke with him?
Last time was August the 3rd. I did a birthday party for my son and he came over maybe 30 minutes.
Do you have any other information as to his income other than just seeing his truck at the location?
No, just that I know that I see he's at the same employer.
And when did you see that truck there?
Maybe 3-4 weeks ago.
Okay. Do you believe that he could at least work a minimum wage job, 40-hour week?
Yes, I know he earns more than that.
Okay. And has Mr. Lopez provided any kind of support for the children since you separated in January of 2022?
Since we separated, he's given me 3 checks, 2 for $250 and 1 for $150.
Was that a total of about $650?
Correct, ma'am.
Okay. Are you asking for child support? Are you asking for back child support or just current child support moving forward?
No, I want back child support.
Okay. I can't remember if I asked you, how are the children covered with health insurance?
I have him on Medicaid.
Okay. Do you know if Mr. Lopez has any other children other than the 2 before the court?
When we were together, I know that he has a daughter in Mexico, but he never had contact with her or helped her either.
Was he sending her any financial support?
No, no.
Not to your knowledge at that time? Okay. No further questions at this time, Your Honor. I just want to make sure I hadn't missed anything.
Miss Laredo, you guys were living together for a pretty good while, right?
Close to a year.
Right. And he wasn't a good dad for the kids when y'all were living together?
He didn't spend that much time with them.
Okay. Is there anything else, Miss Laredo, you think I need to know about this case before I make a ruling?
No, I just want supervised visits because he's not, they haven't seen him more than a year ago already. Like,
Okay. Well, I mean, I'm gonna give him some visitation. It's gonna be restricted, so.
and also on the child support, I know he earns good, so I know minimum would be not fair. It wouldn't be fair because I know he earns
I'm
good.
not setting it based on minimum wage, Miss
Yeah.
Laredo.
Okay.
Okay,
Okay. Thank you, sir.
you're welcome. Anything further from the state?
Nothing further from the state, Your Honor.
The court will find the court has jurisdiction. The court's gonna find based on the testimony of Miss Laredo. It's not in the children's best interest. Miss Laredo, do you live in Jefferson County?
Yes, Your Honor.
Court's going to find that it's not in the children's best interest to name the parties as joint managed conservators. Miss Laredo will be the sole managed conservator. Mr. Lopez will be a possessory conservator. There will be a domicile restriction and any request for non-disclosure is denied. Mr. Lopez will have visitation at any and all times mutually agreed to by the parties. If no mutual agreement, then a phased-in visitation schedule with 12 visits at each phase. That's 12 supervised visits followed by 12 unsupervised visits for half a day, followed by 12 unsupervised visits for the day, followed by 12 one-night overnight visits. Once he gets done with those, then he can have standard possession. Child support in this case is going to be set at $610 a month. The mother will be ordered to maintain the health insurance that she has on the children. There are to be an additional $125 a month in cash medical. Retroactive child support is granted in the amount of $8,500. That'll be paid back at the rate of $100 a month. All payments beginning May 1st of 2023. Mr. Lopez will be responsible for court costs, but I'll give him until October 31st of 2023 to pay my court costs. All right, Miss Laredo, what's going to happen now is they're going to send me an order. As long as it matches what I said here today, I'm going to sign it and get it back to them. Then they're going to make a copy of it and send it to you and to Mr. Lopez, okay? Miss Jasmine
Okay,
Anderson,
thank
would
you,
you
Your
raise your right hand and tell me that your hand is in the air?
Yes, sir. It's in there.
Miss Anderson, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, ma'am. You can put your hand down. Mr. Jerry O. Calloway, raise your right hand. Mr. Calloway, do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you, sir. You can put your hand down. All right, Miss Overstreet, are you handling this case for state?
Yes, Your Honor.
You can call your first witness.
And you are the mother, is it Janiyah?
Yes, ma'am.
And in a previous order, Mr. Calloway was ordered to pay you child support and medical support? Or
Yes, ma'am.
and Your Honor, at this time, I'd like to ask the court to take judicial notice of the prior order in this case.
Court will take judicial notice of its own file.
Thank you, Your Honor. At this time, I'd also like to ask the court to enter in the evidence, the pay records in this case.
You didn't send me an evidence pack on this case?
Well, you know what, Judge, rather than wait for it to get to you, because it may take a while, can we just use the pay records that attach to the pleading?
Certainly.
Okay.
I've taken judicial notice of my own file.
Okay. Ma'am, has Mr. Calloway ever paid you any money for child support or medical support that did not come through the state disbursement unit?
No, ma'am. I haven't received anything from him.
Okay. And the pay records show that as of January 31st, 2023, Mr. Calloway was in arrears in the amount of $10,697.55. And we're asking for a judgment for that amount today. Do you understand that?
Yes, ma'am.
And we're asking the court to order a payout on that amount. We're also asking, as of January 31st, 2023, for a medical support judgment in the amount of $2,847.58 and a payout on that. You understand that?
Yes, ma'am.
Okay. Now, how is your child currently covered for insurance?
She has Medicaid.
Okay. And do you have any personal knowledge of whether or not Mr. Calloway has any other children besides the child that y'all have together under the age of 18?
He has 3 other kids.
Okay. And they're all under the age of 18, as far as you know?
Yes, ma'am.
Okay.
Yes, ma'am.
Your Honor, I have no further questions of Ms. Anderson. I'd like to pass the witness and call Mr. Calloway.
Okay.
You understand that we're asking today, part of what we're asking for today is the judgment for the child support and the medical support?
Yes, ma'am. I'm aware.
Okay. Now, are you currently working?
No, ma'am. I'm unemployed.
Okay. And now, do you live here in Jefferson County?
I do.
There's a program called Choices where you can go into the program and they can help you look for a job. And they have a representative here today on the hearings. Are you interested in going into that program?
Well, right now, I'm able to work due to my medical.
Okay. What kind of medical condition do you have?
I have a disease to my spine called scoliosis.
Okay. Has there been a disability finding?
I filed disability through Social Security and I'm waiting on my answer.
Okay. So you currently can't work at all?
No, ma'am, I can't work right now doing any physical activity.
Okay. But now were you agreeing to modify your child support down to pay $165 a month?
Yes, ma'am, I did agree to that. What I didn't agree was the arrears.
Okay, and we'll get to that. And were you agreeing to pay the $25 a month for the medical?
Yes, ma'am.
Okay. Now, as far as the arrears, is it your testimony you've ever paid her any money directly?
Yes, ma'am. I pay her money directly and I take care of my child.
Okay.
I pay me no money directly.
Miss Anderson, please don't talk, Miss Anderson, until somebody asks you a direct question, okay? Thank you, ma'am.
Now, Ms. Anderson had testified that you had never given her any money directly for the child support. Do you have, how much are you saying that you've given her directly for child support?
Well, I give her money every time she asks me. And when it comes down to the child, basically whatever my child needs, I just do it. When it comes down to clothes, school supplies, whatever she needs, I just basically do it.
Okay. But as far as any cash, have you ever given her any money?
Yes, I've given her cash.
Do you have receipts for that?
No, ma'am, I don't have any receipts. We never really had a relationship to where it got this far. It's just when I lost my job back in December of 2020, and it was around COVID. I haven't been able really to work. So I basically just call me whenever she needs something or my child needs something and I do it. And I just give her cash like that.
Okay. But you don't have an estimate of how much you've given her in receipts for any of that?
I don't have any receipts, but I got an estimate of about $3,000.
And y'all have not lived together any time since the prior order, have you?
No.
Okay. And you have not been incarcerated for any of that time, have you?
No.
Okay. Your Honor, I have, oh, I can't remember. Did you have 3 other children under the age of 18?
Yes, ma'am.
Okay. And you have a child support order on those children?
I do.
Okay. All right. Your Honor, I have nothing further of these witnesses.
Call your next witness.
I have no further witnesses.
All right. Ms. Anderson, is there anything else you think I need to know about this case before I make a ruling?
No, sir, that he doesn't pay me cash like he's saying, and I don't ask him for anything.
Okay.
And my daughter has her own phone to call him, and he calls her when he wants to check on her.
Okay.
We really don't talk because I really don't ask him for anything, sir.
That's fine. The money's supposed to go through the state disbursement unit in the county. That's what the law says. That's what the order says. So, is there anything else, Mr. Calloway, you think I need to know about this case before I make a ruling?
Yes, sir. I'm the one who wanted to speak to the judge from the beginning.
Okay.
My only concern was I lost my job due to a medical illness.
Yes.
And when I was trying to get a review right when I lost my job, child support was behind. They wasn't doing any reviews at the time.
Right.
So September of last year, they finally had moved to the Edison Plaza and they agreed to give me a review. So I've been trying since I lost my job like I'm supposed to, but due to COVID, they told me they wouldn't do any. They couldn't do anything because they was too behind.
Right.
Every time I would file for a review, they would just send the letters back to me in the mail until they finally moved to a new building.
Right.
So here we are now, and they saying I owe 12,
yeah,
15,
whatever it is.
Right. And now here I'm asking that my arrears be based off me not working for this employer because I had to work for this employer since 2020 to 21.
Can't do it, Mr. Calloway.
Well, why is that? Because child support is based off who you work for.
Because the law does not allow the court to go back in time and adjust your child support, Mr. Calloway.
Well, since it was COVID.
I can't. That's the law, Mr. Calloway. I don't make the law. I'm just asked to follow it.
Okay.
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 If you got a complaint against the AG's office because they failed to file a lawsuit on your behalf, that's between you and them. That ain't got nothing to do with me.
No problem.
All right. Anything further, Ms. Overstreet?
No, Your Honor.
I'm confirming the court order as it's been presented. Mr. Calloway and Ms. Anderson, what's going to happen now is they're going to send me this order that y'all attempted to do. And if as long as it matches what's in my file, I'm going to go ahead and sign it, get it back to them, and everything will take effect immediately. Okay.
So as far as visitations, is it still visitation?
There's no lawsuit before me, Mr. Calloway, to adjust the visitation that you have with the child.
So everything is still the same.
Yes, sir. Whatever the prior order says, that's not being adjusted as far as the visitation.
Just kind of visitation. So since I'm speaking to you, you being the judge, she has moved to Baytown, and I don't know where my child lives. For the past 2.5, 3 years, she's up and left, and I don't know where she lives. And by law, I have the right to know where my.
That's absolutely correct. Miss Anderson, did you move out of Jefferson County?
I've been staying in Baytown.
That's not what I asked you, Miss Anderson. Miss Anderson, I asked you if you moved out of Jefferson County.
Yes, sir, I did.
When you moved out of Jefferson County, Miss Anderson, did you send a letter to Mr. Calloway to inform him of where you were moving to?
No, I did not. But
you are in violation. You are in violation. Miss Anderson, do not interrupt me. Stop talking. You are in violation of my court order, Miss Anderson. Because the law in my court order says before you move, you are responsible for sending a letter to the father to notify him of where you're moving to. You're supposed to do that. Not only that, my court order says that you are prohibited from moving to any county that doesn't touch Jefferson County unless you have a court order to do so. Did you go back to court, Ms. Anderson, and get a court order that allowed you to move to Harris County?
I didn't think I had to have one.
Well, that's
If I
what
was
your court
moving.
order says, Ms. Anderson. All right, Mr.
Well, I didn't
Callaway.
know anything about that.
Well, there's no excuse, Ms. Anderson, for not knowing the law. The presumption in this country and in this state is that you not only know the law, but you know the orders that pertain to your children. Mr. Callaway, you have a right to hire an attorney and file a lawsuit against Ms. Anderson for violating my court order. You understand?
Yes, sir.
Ain't nobody gonna do that for you. You gotta do that on your own.
Do you
Yes,
have any
sir.
safety
Good
concerns
luck
or
to y'all.
issues with your
You're free to
address
go.
being in the court order?
No.
Now, in a prior order, Mr. Breda was ordered to pay you child support and medical support for Bailey. Is that correct?
Yes.
Your Honor, at this time, I would like to ask the court to take judicial notice of the controlling order.
Court will take judicial notice of its own file.
Thank you. At this time, I'd also like to ask the court to enter into evidence the pay records in this case.
Ms. Mueller, I've just placed on the screen a copy of the alleged pay records showing the payments that Mr. Breda has made to you and the payments that he's missed. Is it okay if I look at this pay record?
Yes.
Thank you, ma'am. Mr. Breda, same question. Is it okay if I look at this pay record?
Sure.
States Exhibit A is admitted into evidence.
Thank you, Your Honor. Ms. Mueller, has Mr. Breda ever paid you anything directly for child support or medical support that did not come through the state disbursement unit?
Yes.
Did he make any direct payments to you since the time of the last order back in 2020?
Yes, he made it to my daughter.
Okay, but he didn't make it directly to you?
No.
Okay. Now, according to the pay records, as of March 31st, 2023, he owes $62,670.96. And we're asking for a judgment in that amount as of March 31st, 2023, and asking the court to order a payout on that. Do you understand that?
Yes.
As of that same day, March 31st, 2023, he was in arrears in the amount of $6,019.79. And we're asking the court for a judgment for that as well, and a payout on that. Do you understand?
Yes.
Okay. Now, how is the child currently covered for health insurance?
Medicaid.
Okay. Now, do you know whether or not Mr. Breda has any other children under the age of 18 besides the one y'all have together?
Yes.
How many?
One that I know of.
Okay. Now, do you have any personal knowledge of any income that Mr. Breda may have?
Yes.
Can you tell the court what you know about Mr. Breda's income from personal knowledge that you've seen?
The game room that I helped him build, and a car wash, a car detail shop.
Okay. Now you say you helped him build a game room.
Yes.
How long ago did you and he build this game room together?
9-10 years ago.
Okay. And you have personal knowledge that this game room is still in existence and being run by him?
Yes.
How can you tell the court how you have that personal knowledge?
I bring my daughter by there to see him while he's working, and I physically seen him.
Okay. Now, is this game room, to your knowledge, is it open 7 days a week, or when is it open?
Mainly weekends.
Okay. And that's when you helped him build it and ran it. That's it was run on the weekends then too?
Yes.
Now, back when y'all were running it, how much money was it making on the weekends typically?
Each night it'll probably be 8 to 1,000. The max is like 2,000.
Okay. When you say 8, do you mean 800?
Yes.
And do you have any reason to believe that he would be making any less money at that game room now than he did then?
It will probably be more.
Okay. But you don't have any personal knowledge really how much he's making, correct?
No.
But you do see people at the game room?
Yes.
Okay. Now, you also mentioned something about a car wash. Do you have some personal knowledge that he may be working at a car wash?
Yes.
Can you tell the court how you have that knowledge?
Because that's the shop I go get my vehicle detailed at. And he recently, I guess, got hired.
Okay. So you've actually seen him working in the car wash?
Yes.
And you said recently, how long ago did you start seeing him do that?
On the 14th, the 17th, and I think the 20th.
Of what month?
This month.
Do you have any personal knowledge of how many hours he works or what he's getting paid?
I guess from open to close.
Okay, but you don't, you're just guessing, you don't really know.
I don't know what time in the morning, but I know it's to 5 o'clock.
Okay, I'm not asking how long the car wash is open. I'm asking how long do you have personal knowledge, how long he works there?
Well, from what I seen, it was like 10 in the morning to 4 in the evening.
Okay. Now, do you have any personal knowledge of whether he has any other income besides the game room or the car wash?
No.
Okay. Your Honor, I have nothing further of Ms. Mueller. I'd like to pass the witness and call Mr. Breda. And you understand that one of the things we're asking for today is the judgment on the past due child support and the judgment on the past due medical support. Correct?
Yes, ma'am.
Okay. Now, how many other children do you have under the age of 18? Besides the one you have with Ms. Mueller? 2. Do either one of those children live with you?
No, me and my mother have joint custody of the 12-year-old.
Okay. But does the 12-year-old live at your mom's house?
Yes.
Okay. Now, the other child, do you have a child support order on that child?
Yes, my 15-year-old son.
Okay. Now, what are your current sources of income?
Well, first of all, I like to elaborate on this game room 10 years ago.
Okay, sir, can you just answer my question right now? What are your current sources of income?
SSI.
Okay, and how much do you get for SSI?
900.
Okay. Now, are you currently also working at a car wash?
No, ma'am.
Have you ever worked at the car wash?
No, ma'am.
Okay. And your relative doesn't hire you occasionally to work at the car wash?
No, ma'am. I go to different places asking, do they have any kind of work for me to do? And if they do, I do it on that day. I have no continuance, no extra days, no the next week or the next day. It's just whenever I go ask. Okay,
so how often are you going to the car wash or wherever and getting any kind of work for cash payment?
Whenever I need some money.
Okay, so how often do you do that?
Maybe once a week or so.
Okay, so once a week you go and how much do you typically get when you do that?
Maybe 20 bucks.
Okay, so it's your testimony that you work about once a week at a car wash or somewhere else for about $20 a week?
Yeah, I just need some money for my pockets. Yes, about 20 bucks.
Okay. Now, I'm sorry, I didn't mean to cut you off.
It's about 20 bucks.
Okay. Now, are you currently running the game room that you and Ms. Mueller started?
It was never a game room. It was a house where a bunch of fellas get together and shoot dice. It's no machine, it's nothing. It's just a bunch of guys that were shooting dice on a concrete in the garage.
Okay. Now, are you still doing that?
No, ma'am.
When was the last time?
Stop. Have you advised Ms. Overstreet, Mr. Breda, his right to remain silent?
Sir?
That's okay, Mr. Breda. I'm asking the state's attorney.
No.
He's advised you of your right to remain silent.
No, I didn't.
You're asking Mr. Breda to basically indict himself for illegal gambling.
Yeah, I wasn't
Under
thinking
oath.
about it being illegal.
Basically what you're saying is that the house is making money on illegal gambling activity. That's a violation of the laws of the state of Texas.
Right.
Let's move on.
Okay. Sir, do you rent or own your own home?
No,
Where do you live?
I have an apartment in Port Arthur.
Okay, so you rent an apartment. How much does that cost you a month?
200 something. My mother pays my bills. My mother pays everything. She gets my check and she pays everything for me. That need to be paid.
Okay. Do you have a car?
No.
And how do you get around?
I have relatives that take me places that I need to go, and whenever I'm feeling good that day or something, one of my cousins or something, they might allow me to use the car maybe an hour or two or so.
Okay. So your mother pays your rent with your $900?
Yeah, she pays all my bills.
Okay. What other bills do you have?
Cell phone, internet, and Wi-Fi, my insurance, my rent.
How much is your cell phone bill?
Like $120.
And how much is your internet?
It runs like between 150 and 160, something like that. 150, I believe.
How much is your internet different than your Wi-Fi? Are you paying like a
No,
cable bill
it's
too?
cable. Yeah, it's Spectrum cable. It's like 150 a month.
Okay. And what kind of insurance do you have?
I have life insurance.
And how much is that?
I have no idea. She just tells me what she pays.
Okay. Do you have any other?
I have like sometimes I have like $100 left over, and she tell me don't use it wisely.
I'm sorry. Don't what?
Use it wisely.
Oh, okay. Thank you. I couldn't hear. So do you have any other bills you haven't talked about?
Not that I know of.
Okay.
Can I say something?
Not yet, Brayden. Just answer
Okay.
questions, okay?
Yes, sir.
Thank you.
I have nothing further, Your Honor.
Call your next witness.
I have no further witnesses.
Ms. Muller, there was some early testimony from you in direct questioning from Ms. Overstreet regarding a game room. Do you understand that this game room has some type of video machines that Mr. Breda may be making money from?
It's not video machines, it's tables, and even the city knows about it.
No, you're talking about table games like dice and cards.
Yes.
Yeah, that's illegal. You can't do that. That's
They never shut them down.
Whether they know or don't know is irrelevant, Ms. Muller. It's illegal. You can't do it in this state. There's no such thing as house-controlled gambling.
It's not a house. It's okay, whatever.
You understand what I'm saying? That means where people come in off the street and they gamble and the house gets a cut. That's illegal.
Okay.
If 5 or 6 people come to my house and we all sit around playing poker, that ain't illegal. But if 5 or 6 people come to my house and I charge them money to sit down and play poker, that's illegal. And I'm guilty of a felony. Okay. I can't set child support, Ms. Muller, based on felonious activity. Which I think is probably what happened in 2017. Miss Overstreet, is the state asking me to modify this child support?
Yes, Your Honor, we're asking to modify based on his current income.
Which is what?
Well, he doesn't have any. He's been declared disabled.
He's never had any. So what's the substantial change of circumstance? Have you looked at the prior orders in this case, Ms. Overstreet? There's an SSI finding on the original order in this case in 2013.
Oh.
Then there was a private modification that was done with Ms. Muller through her attorney, Mr. Packard, in which case the AG's office was involved and signed off on the default order against Mr. Breda that increased his child support to $750 plus $75 for cash medical. Even in that finding, there's no finding by that Mr. Breda actually is employed. if you look at the actual order itself. Did you review that?
Actually, I had just reviewed the prior order. Sorry, I didn't look at the one further back.
Because I mean, my question to Mr. Breda would have been, Mr. Breda, how long have you been on SSI? I didn't have to ask that question though, because there's an SSI finding in the 2013 order. So what's the material substantial change of circumstance since the 2017 order?
There actually isn't one, Judge. So.
Kind of tough spot, ain't it? Mr. Breda is now $65,000 behind in child support and medical support based on an order from 2017 that has no basis in fact. None. Okay. Anything further from the state? What do you want to do, Ms. Overstreet? That's your lawsuit.
I was still trying to pull up the prior order, Judge, to read what it said.
The 2013 order says obligor receiving SSI benefits in the findings page.
And that's the only finding there was?
Well, everything's set at 0 based on his SSI finding.
And they had proved self-employed with the other judge based off pictures and internet findings and what he would say and tell people.
Okay.
That's what that judge signed.
Well, I mean, he didn't participate, Ms. Mueller, so I get it. But there's no finding. The problem that I have in the whole situation is that nobody's been able to give me any evidence that there's a material substantial change in circumstance.
I don't know what that means.
Well, in order for me to change the child support, Ms. Mueller, there has to be a change from the last court order. And I don't necessarily know that I see one.
I didn't ask for.
Then Judge, I guess I almost got it pulled up, but if then you just probably need to deny my motion.
Well, I may.
What was this court date for?
Well, I'll tell you why, Ms. Mueller, based on what I've heard. The AG's office filed a lawsuit to adjust Mr. Breda's child support to 0 based on the fact that his only source of income is SSI. Okay. If you will remember, and it's been a long time ago, but in 2013, when this court order was first started, there was a finding that said Mr. Breda's receiving only income from SSI. And therefore, the child support and the medical support was set at 0 because the federal government says the courts are not supposed to use SSI as the basis for child support and medical support. You with me so far?
Yeah, and the other judge knew that as well.
Well, but I'm looking at the court order from 2017, the one where you had Mr. Packard representing you and Mr. Breda didn't show up. All right, I'm looking at that court order, and it does increase the child support to $750.
Based off the findings of his other sources of income, which was self-employed, and we had witnesses, pictures.
Right. And you put all that on the record, all those witnesses and all those pictures. I mean, they all got on the stand and testified to all that stuff?
At the time.
Okay. I mean, I wasn't there. That's why I was asking.
Oh, at the time, then that's what.
I wasn't the judge. That was heard in front of Judge Shelton.
And he looked at the photos, the pictures, and with him with stacks of money, like they sent in all that.
Okay. Well, I mean, I'm assuming your attorney put that all on the record. Anything further?
No, Your Honor.
I mean, I don't have a choice. Your motion's denied. I'll grant the judgment, $62,670.96 plus $6,019.79. The child support judgment would be paid back at a rate of $300 a month, and the medical support judgment would be paid back at $50 a month, but the mod is denied.
Did you say, is the payout going to start May 1st?
Yes, ma'am.
Okay.
All right.
I have nothing further, Your Honor.
All right. Mr. Breda and Ms. Mueller, they're going to send me a proposed order. If it matches what I ordered here today, I'm going to sign it and get it back to them, and they'll make a copy of it and send it to each of you.
What's the your order?
Well, Mr. Breda, your child support probably ought to be 0 because you're receiving SSI. But I can't modify it because there's already an order in existence that sets your child support based on what it could be due to some unknown income that I don't see. But the order, I understand, Mr. Breda. I get it. But I mean, the order is what it is from 2017, and the state went along with it as well. So I'm not really sure why they filed this motion for me today, but that's, they did. So this was with agreement. I didn't have any type of blood test or anything with this child, and
Last year, I called Ms. Muller last year, January, and told her that I was going to do everything I possibly can for this child. Even though we didn't take a blood test or anything, I was going to claim the child and do what I can do.
Right.
And ever since January 1st of last year, I called her phone and told her this. Right. And ever since then, I've been doing things for the child, for the baby and everything. Good. The child looks at me as I'm her father. She knows my other kids, and we do things together now.
Right.
So I've accepted her into my family as my child.
Good. I mean,
I don't understand
that you're being a good father to the child.
Yes, and I really don't understand why Miss Muller telling you all of these things when she knows it's false. When I stepped up and started doing the things that I'm supposed to do. She knows this, and she's on the phone and she hear me talking.
Okay.
Everything that I possibly can do, I do it.
Right.
And I spend time with her. They just called me last week saying that she wouldn't clean up, and I spoke to my daughter for about 30 minutes asking her why she wouldn't clean up.
Right.
I don't treat her no different than my other kids now.
Right. Well,
so I really don't understand
I'm glad for that,
why.
But he gives me a hard time.
Ms. Muller, I didn't ask anything, Ms. Muller. Just hold on. Just stop.
I truly, it hurts me.
Let him say his piece, Ms. Muller, because I can't help him. The law doesn't allow me to help him, or I would. Because I'll be honest with you, Ms. Muller, his child support should be zero. He shouldn't be paying his child support if the only form of income he has is SSI. And I've got no evidence whatsoever that that he has any income other than SSI. But that prior order from 2017 says he does. And until I hear something that changes that court order, I can't modify it.
Well, I know one thing: God doesn't sleep. He's a God. I believe in God, and this is going to come to court again because I have more time than I have money, and I've been spending time and doing everything I possibly can. These odd jobs that I do, is some of the money goes towards my daughter, like the $150 tennis shoes I just recently bought.
Well, Mr. Brady,
these places that I take them.
Hold on, stop, Mr. Brady. Okay, look, I don't mind you giving me information that can help me make a decision about your case, but
I understand that you can't. It's all good, but I know it's going to come back to court again. It's going to surface again because I can't afford to pay these payments.
Okay. Well, you have the right, Mr. Breda, to file an objection to my ruling today with the district clerk's office as long as you do it within 3 days, okay?
Yes, sir.
And then you can get you another hearing in front of Judge Shelton, and maybe he'll change his court order from 2017, all right?
What is the court order?
No, I'm not changing your child support. It's staying at 750 plus 75. Okay.
Okay.
All right. So you got 3 days to appeal me if you want to do so. Okay.
It's going to go back to court again. I don't know. It's going to return back.
Okay. Well, don't wait. You got 3 days to appeal it if you want to do so. Okay.
But I have no information on how to go about doing it.
So all you got to do is find a way to get to the Jefferson County Courthouse in the next 3 business days and file a handwritten note in your file that says, I want to appeal Judge Webster's ruling. That's all you got to do. What?
Let me ask you a question. Since I've never taken a DNA test or anything.
You can't have one of those, Mr. Breda.
You say I can't?
Nope. You got to go file. In a case like that, you'd have to go hire an attorney, and there is a big old hard lawsuit you have to file to try to get a court order that's 10 years old overturned.
Mm-hmm.
You know, you don't have a right to go back 10 years and try to litigate stuff, Mr. Breda, that should have been litigated when you first case in front of me in 2013.
I accepted that responsibility last year.
You don't get to change your mind on that now, then.
Yeah, it's understandable.
All right. Good luck to you, Mr. Breda. Good luck to you, Ms. Muller. You're both free to go, okay?